In Cooper v. Aaron, the Supreme Court indicated that it considers its decisions to be authoritative interpretations of the Constitution. Its decisions tell us what the Constitution means, and they must be accepted by the state and local governments as well as the other branches of the national government. This issue about the extent to which the Supreme Court really is absolutely supreme when it comes to interpretation of the Constitution is still controversial today. For example, the issue got a lot of attention in the 1980s during the Ronald Reagan administration when Ed Meese was the Attorney General. He stirred up a lot of debate and consternation with a speech he gave that criticized Cooper v. Aaron. He thought the Supreme Court had gone a little overboard in that case by saying that its decisions were part of the supreme law of the land. So there was quite a bit of debate and discussion of this. And it's an issue that's still been debated in more recent years. For the most part, it's been something that has divided along political lines, with conservative figures being those who question the extent of the Supreme Court's authority. For example, Newt Gingrich stirred up some talk about this issue when he was running for president in 2012. His campaign put out a paper on bringing the courts back under the Constitution. And it argued that this notion of judicial supremacy is wrong. It said the court's assertions in Cooper v. Aaron were factually and historically false. And it cited how presidents had stood up to the Supreme Court in the past, like Thomas Jefferson, Andrew Jackson with his national bank veto, Abraham Lincoln with his defiance of the courts during the Civil War, and Franklin Roosevelt with his court-packing plan during the Great Depression era. But Gingrich said that since Cooper v. Aaron, Congress and presidents had been just going along with it and accepting the idea of judicial supremacy and not challenging it, and that he thought this was a big mistake. Gingrich laid out a list of things that should be done about it. He wanted Congress to start stripping the Supreme Court's jurisdiction over issues that the court was not deciding properly. And he suggested that Congress might want to abolish some of the lower federal courts if those judges were making inappropriate decisions. He wanted to have judges impeached for making bad decisions. He wanted Congress to hold judicial accountability hearings where members of Congress could express their displeasure with judicial decisions and require federal judges to come before them and explain their reasoning and listen to members of Congress explain to them what would be the correct interpretation of the Constitution. And Gingrich argued that in very rare circumstances, the president might choose to ignore a judicial decision. For example, if Congress passed a law stripping the court's jurisdiction, and then the court tried to say that that law was invalid, perhaps the president should simply ignore what the court said about it. So, this was a very controversial position to take, and there was definitely a lot of people who felt the same as Gingrich, and other people who harshly criticized him for it. It was interesting how Gingrich delved into the history of the issues, as he used to be a college history professor before going into politics. And he focused on European history, but he was quite interested in American history as well.
I want to talk to you a little bit about this whole business. You really turned up the heat on what you call activist judges. You talked about this the last time you were on Face the Nation, and yesterday you had a telephone conference call with reporters because you want to put this out front and center. In fact, your folks said to me, be sure and ask him about judges. So I know this is something you want to talk about. Basically, what you said was that sometimes in the past, presidents have paid no attention to the Supreme Court when it issued a ruling, and you said there might be times, or there would be times now, when a president should just ignore the Supreme Court. I'm not sure I understand how that works.
Well, Bob, I think part of the advantage I have is I'm not a lawyer. And so as a historian, I look at the context of the judiciary and the Constitution in terms of American history. The fact is, I'll just give you two examples. Judge Beery's ruling on June 1st that he would jail the superintendent. If anybody at the high school graduation used the word benediction, used the word invocation, asked for a moment of silence, asked the audience to stand, or mention God, he would jail the superintendent. It's such an anti-American dictatorship of speech that there's no reason the American people need to tolerate a federal judge who is that out of sync with our entire culture. And so you have to ask the question, is there any alternative? What's the recourse? Well, one recourse is impeachment. The Supreme Court in Boumediene literally inserted the American civil liberties onto the battlefield. Now, this is the opposite of World War II, where Franklin Delano Roosevelt told the Supreme Court through his Attorney General that the 14 German saboteurs that had been picked up in the U.S. would be tried by military tribunal and executed, and that he would not tolerate a writ of habeas corpus as the commander-in-chief. And so you have this real problem that since 1958, when the Warren Court asserted by itself that the Supreme Court was supreme over the president and the Congress, you've had a fundamental assault on our liberties by the courts. You have an increasingly arrogant judiciary. And the question is there anything we, the American people, can do? Well, the standard conservative answer has been, well, eventually we'll appoint good judges. I think that's inadequate. The Constitution promises a balance of the judicial branch, the executive branch, and the legislative branch. The Federalist Papers says specifically the weakest of the three branches is the judiciary. Jefferson abolishes 18 out of 35 federal judges.
They've just been created.
They've just been created and they've been appointed. And he abolishes them. Over half of all the judges. Jackson says of the court, they think the Bank of the United States is constitutional. I don't think it's constitutional. Their opinion doesn't matter to me. I'm the president. They're over in the judiciary. He vetoes it. Lincoln spends part of his first inaugural, because people tend to forget, the Supreme Court in Dred Scott ruled that slavery extended to the whole country. And Lincoln said very specifically, that's the law of the case. It is not the law of the land. 9 people cannot create the law of the land, or you have eliminated our freedom as a people.
More recently, some presidential candidates have also raised issues about Cooper versus Aaron and whether it went too far with its assertions about judicial supremacy and the power of the Supreme Court.
And you also seem to indicate that as president, you wouldn't necessarily obey court rulings, even the Supreme Court. Here you are.
Many of our politicians have surrendered to the false god of judicial supremacy, which would allow black-robed and unelected judges the power to make law as well as enforce it.
But, Governor, we have operated under the principle of judicial review since the Marbury versus Madison case in 1803.
Judicial review is exactly what we've operated under. We have not operated under judicial supremacy. Presidents Lincoln, Jefferson, Jackson, presidents have understood that the Supreme Court cannot make a law. They cannot make it. The legislature has to make it. The executive branch has to sign it and enforce it. And the notion that the Supreme Court comes up with a ruling and that automatically subjects the two other branches to following it defies everything there is about the three equal branches of government. Chris, the Supreme Court is not the supreme branch, and for God's sake, it isn't the supreme being.
But sir,
it is the Supreme Court.
But sir, George Will, the conservative columnist, has pointed out that back in 1957, another governor of Arkansas, Orville Faubus, decided to disregard and refused to obey the Supreme Court's ruling to desegregate schools. President Eisenhower had to call in the 101st Airborne. Are you saying that President Huckabee might decide he wasn't going to obey the ruling on desegregation, or like President Nixon to turn over the tapes, that, you know, it's up in the air as to whether you're going to obey the Supreme Court?
Well, Chris, as you know, George Will is no fan of mine. He's not very fond of me. He recently called me appalling. So I'm not surprised that he would make such a false comparison. But the point is, in that case, the Supreme Court had ruled, the legislature and the executive branch had agreed with the Supreme Court, and precisely what happened is what should happen. The president ordered the airborne to come in and enforce the law that did exist. But it wasn't that the president defied the law. The president was carrying out the law and using all the forces at his resource to do it.
But okay, let's say the president decided, I don't like
the Supreme Court's ruling on that? Let's say Nixon had said, for instance, in Watergate, I don't want to turn over the tapes and the court can't make me.
Well, the president still has to follow whatever the law is. Does Congress have a law that tells him what he's going to do? In that case, the Congress was ready to impeach Nixon, and he ultimately resigned. I want to get back to the main point here. It's a matter of balance of power. If the Supreme Court could just make a ruling and everybody has to bow down and fall on their faces and worship that law that isn't a law because it hasn't been yet passed, then what if the Supreme Court ruled that they were going to make the decision as to who was going to be the next president and save the taxpayers and the voters from all the expense and trouble of voting, and they'll just pick a president? Well, we would say, well, they can't do that. Why can't they do it? They can't do it because it's not in the law. We are sworn to uphold the Constitution and the law, and it has to be consistent and agreed upon with three branches of government. One can't overrule the other two. That's all I'm saying. We learned that in ninth grade civics, but I'm convinced a lot of Ivy League law schools must have forgotten that simple, basic civics lesson along the way.
Election fight you got with George Pataki, the three-term governor of New York, about the role of the judiciary. Let's watch this fight. This is the kind of fight we had in high school.
Judicial supremacy is not in the Constitution, and we need a president and a Congress to stand up to a court when it exceeds its constitutional authority.
Thank you, Senator. Governor Pataki, your response.
And my response is kind of wow. You know, we're going to have a president who defies the Supreme Court because they don't agree.
If they're wrong,
then you don't have the rule of law.
No, and what you have is judicial supremacy. You don't have a rule of law when the court has the final say on everything.
The elected representatives of the people always have the opportunity to change that law.
Senator, we've lived our lives with landmark decisions by the Supreme Court, whether it's Brown, whether versus the Board of Education, which said no more separate but equal in public schools. The courts knocked out prayer in public schools in the prayer case. They basically reviewed the Civil Rights Bill of '64 and found it constitutional. We had Roe v. Wade in '73.
Yeah,
you've had these, but they've all been Supreme Court, and many of them 5-4 decisions.
But we also had Brown versus Board of Education. We also had Plessy. No, you didn't. But you also had Plessy versus
Brown.
You also have Plessy versus you also have the Dred Scott decision.
Okay, but that's back before the Civil War.
Well, you had Plessy versus Ferguson, which was not that was before Brown versus the Board of Education.
By Brown.
The point is, courts get it wrong sometimes. Number one. Number
who's
two,
to say that?
Who is to say that?
Well,
should we just wait for the court to do it?
You're saying if we don't like the ruling on same-sex marriage, we do what?
It's called checks and balances.
What do you do about it?
You have a president who stands up and fights the court. President Obama has done that on occasion, as you know. And you got, number one. Number two,
overrule the Supreme Court?
You challenge the Supreme Court.
How do you do that?
Well, because you raise your hand when you're president of the United States and say, I uphold the Constitution of the United States.
As reviewed by the Supreme Court.
No, well, who has the final say?
By Marbury versus Madison.
And who said that?
The Supreme Court did.
The Supreme Court said we get the final say.
History, accepted throughout history.
Not accepted by history. Abraham Lincoln passed a law that violated Dred Scott decision. So no, the court is only one of three equal branches. It's not the superior branch.
So you're saying
that
this president or any president could have ignored the decision on same-sex marriage?
It could contest the decision when a court acts beyond their constitutional authority. It's not when the court acts within its right. You mentioned to me earlier the Bush v. Gore decision. Well, that was within their right to take a factual situation and try to apply the law. There was really nobody else that can make that decision. In this case, the court exceeded its authority under the Constitution, and there are several justices who agreed with me on that. They have no right under the Constitution to do what they did, and when they act beyond the Constitution, someone has to check.
Well, they did. They made that judgment on same-sex under due process and under the Liberty Clause,
which is what they made the Dred Scott decision on.
Well, they made it, and that was the judgment. You would have overruled it.
I would.
You would have overruled it.
I would have contested it. In fact, I will as president.
Thank you, Senator Sitterm. Thank you for coming on.
So in these examples I've given, it was more conservative politicians who were questioning the authority of the Supreme Court and the logic of the Cooper versus Aaron decision. Liberal politicians and commentators were more inclined to have a favorable view of the Supreme Court's assertions of its authority. The political alignment on these issues may be due in part to underlying ideological differences about what the role of the court should be. but they almost certainly have something to do with how people feel about what the Supreme Court's doing. In other words, people's differing attitudes toward the Supreme Court and its authority may have a lot to do with who is on the Supreme Court and what sort of decisions the court is making. This became apparent in 2017, 2018, 2019, 2020, when there were significant changes in the membership of the Supreme Court that made it clear that the court was going to have a majority of justices who were very conservative. For the first time, you then really had some people on the liberal side of politics talking about the Supreme Court in ways that they previously had not.
Oh, how the tables have turned.
It was now some liberal observers who started thinking about things like jurisdiction stripping legislation, or court packing, or whether the power of judicial review should be limited or even abolished altogether. So clearly these are issues that are not going to go away, although, at least for the time being, some people's positions on them may have switched due to new circumstances.